thank you again for joining the Landmark Chambers webinar this morning on current issues in immigration detention. We're delighted that so many people are joining us. We hope you find the presentations helpful and informative. I'm Graham Denholm. I'm head of the immigration team at Landmark. We were to be joined by our colleague Fiona Spalding QC this morning to chair the session, but she's unfortunately not able to attend. So I was going to be one of the speakers, so I'm going to be chairing and speaking, which means I can ensure that all the difficult questions go to Philip and Alex and not to me. Before we go on to the substance of the talks, and before I introduce the speakers properly, I just want to deal with a few brief housekeeping points. The first thing to note is that your microphones are automatically muted, so you don't need to adjust your local settings during the course of the webinar. We very much welcome questions as the session is ongoing. We'd ask you to submit them via text in the Q&A section, which you can see at the bottom of your screen, and we'll try and deal with as many of those as possible in the time available at the end of the session. The webinar is going to be recorded, and you'll be sent a link to the recording when that's available after the event has concluded. And if at any point in the course of the webinar you lose your connection, we would invite you to rejoin by simply clicking the original link that you used to join in the first place. Okay, so let's begin. I'm going to start by just briefly introducing the topics and the speakers. The topic for the session today is current issues in immigration detention, of which I'm sure everyone attending is aware that there are many. We certainly can't deal with all of them, but we hope we've focused in on some fairly interesting and topical issues that will be of use to practitioners working exclusively or partly in this area. Alex is going to be looking at issues arising out of Schedule 10 bail. Philip is going to be looking at the adults at risk policy, and particularly the way that has been applied and issues that have arisen out of its application in the context of the pandemic. And I'm going to be looking at issues relating to the Detained Fast Track, which, well, one might think is not necessarily a terribly current issue, given that it ceased existing about 5.5 years ago, but I hope I can persuade you that it does have some current relevance. So to the speakers, so Alex Goodman is a well-known practitioner in the public and immigration law world, working across a range of areas, including planning law, environmental law, and civil liberties. He's described in Chambers and Partners as calm, brilliant, and a joy to work with, and he's very well known for his work in immigration detention, having been involved in major cases in the area, right back as far as Lumber. More recently, his work has taken in the litigation around the Brooke House inquiry arising out of the BBC Panorama documentary, and he has a particular interest in some of the complex issues arising out of the 2016 Act bail regime, which he's going to be speaking about today. Philip Nathan is a very well-known and highly respected practitioner in the immigration field. His practice encompasses the whole range of asylum and personal immigration work in the tribunals, as well as a range of judicial review work in the higher courts. He's recently in the Court of Appeal in the case of Al Enain, I think is how one pronounces that, on issues around nationality, and he has very broad experience of the whole range of issues arising in the context of immigration detention. And as I said, I'm the head of the immigration team here at Landmark. I practice across public law and the full range of immigration work, although it's fair to say detention has become something of a niche specialism for me, and a significant proportion of my practice now involves either judicial review challenges to immigration detention or civil claims arising out of immigration detention. Anyway, that's enough from me, so if I can pass over to Alex to begin the talks. Thank you.
Thank you, Graham. I'm going to be talking about two cases today, the case of Humlinski and the case of Kaiti. The Humlinski case, first of all. This case was about three claimants who were affected in different ways by a refusal to grant bail accommodation. Mr. Hamlinski himself was granted bail so as to be released from immigration detention, where he'd been held for 16 months. But a condition on the grant of bail was that he be bailed to an address, and he didn't have an address. And so he applied to the Secretary of State for an address pursuant to Schedule 10. There's a power to provide an address in Schedule 10, which I'll come back to, of the Immigration Act 2016. But the Secretary of State failed to provide an address, essentially because of a systemic under-provision of bail accommodation. So Mr. Hamlinski and others, by the time his case came on, he had in fact been removed from the jurisdiction, but there was still a potential damages claim at one point, which he dropped on the eve of the hearing, but still wanted declaratory relief to vindicate his rights. There was an argument about whether that made it academic, but Judge found that there was significant reason to continue considering the case. Now, Mr. Hamlinski therefore argued that the failure to provide him with an address, a bail address, rendered his detention unlawful because he was effectively being kept in detention pending provision of a bail address, and argued that the failure of the Secretary of State to properly consider the power under Schedule 10 to grant him a bail address was unlawful, and that had the knock-on effect of making the detention unlawful. Mr. Justice Johnson held that a reasonable period for ascertaining a suitable address in all the circumstances was 1 week. And that was in the context of quite a complex case, because an address had to be approved by the probation service in this case. And the failure to provide a bail address accommodation within that period so that he could be released then rendered the detention of the claimant unlawful. Mr. Justice Johnson held that the Secretary of State's policy for the provision of accommodation under the Immigration Act 2016, Schedule 10, to individuals granted immigration bail was systemically unfair. And he held that she'd fettered her discretion in the individual case and in the policy by not specifying the categories of case that were capable of amounting to exceptional circumstances. If we just go to the next slide, one sees under paragraph 9 to Schedule 10 that the Secretary of State has power to enable person to meet bail conditions. And if you have a look at that slide there, subparagraph 2 applies where a person is on immigration bail subject to a condition requiring the person to reside at an address specified in the condition, and 2, the Secretary of State may provide or arrange for the provision of facilities for the accommodation of the person at that address. But under subparagraph 3, the power applies only to the extent that the Secretary of State thinks there are exceptional circumstances which justify the exercise of that power. And if you have a look at the judgment, it's paragraph 165. In the individual case, the Secretary of State failed to consider whether there were exceptional circumstances. And that was in essence because the policy doesn't provide properly as to the categories of case amounting to exceptional circumstances. And so the decision was unlawful, and for that reason his detention also was unlawful. So the case is a pretty important one because it both establishes the systemic unfairness of this system and because it will affect quite a lot of people. There are many hundreds of people in detention in very similar situations who get granted bail. And I'm sure many of you attending this seminar will have come across this, where you can't then get them released because there is no address. So a very useful decision, and it's also a useful decision generally on the approach to be applied to system challenges, which are becoming more common. So any kind of challenge, whether to a detention policy or some other aspect of immigration policy, the case law up until that decision of Mr. Justice Johnson's all summarised quite helpfully in the case. I'll move on to the next slide and to the next case then. This is a case of Katie, 2023 Weekly Law Reports 936. Again, this is all about Schedule 10 to the Immigration Act 2016. And I'm going to run through the statutory provisions first of all, because it's really a case all about what those statutory provisions mean, and it will be helpful to have read through them. So you've got it up on the slide in front of you. Paragraph 1.1 of Schedule 10 to the Immigration Act 2016 provides the Secretary of State may grant a person bail if the person is being detained, and then it specifies, in essence, all the immigration detention powers. So that's paragraph 16 of Schedule 2 to the 1971 Act, paragraph 2 to Schedule 3 of the 1971 Act, section 62 of the 2002 Act, and section 36 of the UK Borders Act 2007. So in essence, any of the immigration detention powers, if a person's being detained, then the Secretary of State has a power to grant that person bail. Subparagraph 2 of paragraph 1 to Schedule 10 of the Immigration Act then says, the Secretary of State may grant a person bail if the person is liable to detention under a provision mentioned in subparagraph 1. So liable to detention is the key phrase there. And then subparagraph 5 to paragraph 1 to Schedule 10 provides that a person may be granted and remain non-immigration bail even if the person can no longer be detained if A, the person is liable to detention under a provision mentioned in subparagraph 1, or B, the Secretary of State is considering whether to make a deportation order. So that's paragraph 1, 2, and 1, 5. They're important. The power is to grant bail to a person liable to detention, and that can include a person liable to detention who may no longer be detained. And in the case, it's really all about what that means. If we move on to the next slide, we then see paragraph 10 to Schedule 10 provides for a series of powers of arrest and detention in the case of a breach or an apprehended breach of bail. So first of all, one sees subparagraph 1, a person may be arrested and then may be detained under the authority of the Secretary of State. And then if they have breached bail or are likely to breach bail. And then by paragraph 10, subparagraph 12, if it's decided a person has breached bail or is likely to do so, the Secretary of State or the first tier tribunal, as the case may be, must either direct that the person be detained under the power to which they are liable to detention under paragraph 1.1 or grant the person bail. So one can see that paragraph 10.12 makes it mandatory to detain a person who is liable to detention under the powers mentioned in paragraph 1.1, i.e. all the immigration detention powers, for a breach of bail condition. So if you fail to report or fail to reside at the specified address, work in breach of bail condition, etc. The redetention has to then be under that power to which they are liable to detention. And so that raises the argument, as arose in the Katie case, that what happens where a person can't in fact be detained because the detention would be incompatible with the Hardial Singh principles, for example, because they can't be removed. The claimant, Mr. Katie, argued that it was integral to the statutory scheme read as a whole that a breach of bail may entail redetention pursuant to the underpinning power to which that person is liable to detention. And it's therefore evident, he said, that the scheme, when it refers to a person liable to detention under paragraph 1, is referring to a person who may be lawfully detained under that provision, and not to a person for whom detention would be incompatible with one of the Hardial Singh principles. And so it's evident that the scheme is essentially applying an ordinary approach to bail that has existed for many hundreds of years, and not an extraordinary form of bail at which the defendant asserted. So putting the matter the other way around, if a person could be granted bail because they were liable to detention, but that then didn't mean liable to lawful detention, then paragraph 10.12 is mandating the relevant authority must detain a person unlawfully. And the claimant said that can't be right. It's requiring a person to be falsely imprisoned. And that obviously isn't its meaning. So let's say, for example, a person breaches a condition by working on a job, not on the shortage occupation list, then his redetention is mandated under paragraph 2.3, even though that detention would be Hardial Singh incompatible. So if we just go back to the previous slide, back to paragraph 1, you can see paragraph 1.5 to Schedule 10 says a person may remain on bail if they are liable to detention, even if they can no longer be detained. The claimant argued that this refers not to people who are not liable to lawful detention, it doesn't refer to people who are not liable to lawful detention, because that would make a nonsense of the power to redetain. It clarifies that when a person is granted conditional bail, that is lawful, even though implicit within such a grant will be recognition that while they are liable to detention, it's not proportionate or justified to detain them. So that's the argument. I'm going to sort of expand that a bit now. Now, this claim was one of a whole series of claims, and the Secretary of State conceded all of them, all the previous claims favourably to the claimant, and in each case, in fact, granted leave. So each of the previous claimants were people who'd been in the UK a long time. Their removal had become effectively impossible. No realistic prospect is the test. And in each case, the Secretary of State had conceded the argument. Clearly, the Secretary of State must have liked the Kitey case most of all, because it was the one case they didn't resist. And so this case went ahead to test this important issue as to the scope of the Secretary of State's powers to grant bail. And it is an important case because BID's evidence, bail for immigration detainees, showed, they intervened in the claim, that there are in excess of 90,000 people now on Schedule 10 bail. So it's a very large number of immigrants affected by this. And that's because the former categories of temporary admission have been abolished by the new bail regime. So in effect, anyone who is not granted leave is on bail unless they're simply at large. Mrs. Justice Lang found in favour of the defendants, but she granted permission to appeal. And so there's going to be a hearing in February or March next year in the Court of Appeal. And so the main question at issue in what's now to be the appeal from the decision of Mrs. Justice Lang is whether a person may remain on bail where it would be unlawful to exercise the power of detention in respect of them. And the most obvious circumstances, as I've said, in which that arises are where detention would be incompatible with the Hardial Singh principles, for example, because there's no realistic prospect of deporting them. And I expect many of you will have come across cases of that nature, particularly for people from countries like Algeria, Morocco, Eritrea, China, Palestine, Iran, where it's very difficult to secure travel documents through negotiations with the diplomatic services from those countries. And that's the position in Mr. Kitey's case. He is as close as can be to stateless. In fact, he has an outstanding claim to be stateless. But the question of whether a person can be on bail, even though they cannot be detained for breach of bail, might also arise, for example, where it would be unlawful to detain them because of their vulnerability. They're a trafficking victim or a torture victim. There's also a separate way of putting the argument in the claim and the appeal, which is whether implied limits on the exercise of the bail power, whether limits can be implied into it, similar to the Hardial Singh kind of approach, that there comes a point when it's unreasonable to simply maintain a person on bail indefinitely. So both of those arguments applied to Mr. Kitey because he'd been in the UK since 2006 and was released from immigration detention by order of the First Tier Tribunal on bail in 2011 and subject to electronic monitoring. So he's been on bail now for 10 years. And in that time, his bail conditions have been relaxed. So he's no longer subject to electronic monitoring. He is now permitted to work and he's committed no further offences. And in that time, it was contended by Mr. Kitey that there is no realistic prospect of deporting him. So if he were detained, he would simply apply for habeas corpus or a writ of habeas corpus or judicial review of his detention, and he would be released. I mean, he was released on bail on the basis that his deportation was not realistic in January 2011, so almost 10 years ago, and there's been no progress since then. It's quite obvious, he said, given there's been no progress, there's no reasonable prospect of him being deported, he shouldn't be on bail for which he can be detained if he breaches the condition of his bail in the interim. Now, the argument was all based on a Supreme Court case called B. Algeria. And in that, the Supreme Court recognised the term bail was a legal term of art with hundreds of years of consistent meaning. And it held in that case that because Mr. B couldn't be detained, he couldn't be held on bail. But that was under the former regime of the 1971 Act. So the argument that was being made for Mr. Kaiti succeeded under the old 1971 Act bail regime. And the question is whether it applies now to the 2016 Act. Now, the Supreme Court distinguished a case of Khadir, Khadir, which was an old case in the House of Lords. It's about 18 years ago. And that concerned whether a person could be maintained on what was then temporary admission, where a detention power existed, even if the power could not be exercised. And the Supreme Court said that there was a distinction because bail was a very different form of control to temporary admission. Bail had a meaning, a legally prescribed meaning over hundreds of years of common law. And canons of construction provided that any bail power, just like a detention power, had to be strictly and narrowly construed. So, for example, at paragraph 29 of the Supreme Court judgment, they say, it's a fundamental principle of the common law that in enacting legislation, Parliament is presumed not to intend to interfere with the liberty of the subject without making such an intention clear. So the claimant in Katie is arguing that a conditional grant of immigration bail under the 2016 Act is also derivative of a power to detain, and that's ordinarily the case. And so for that reason, if that person were to seek a writ of habeas corpus, they could even issue it to bring bail to an end. That's based on some 19th century cases and the 1941 case. The writ will then issue so as to mark the exhaustion of the power to detain from which the bail power is derived. And so the corollary of a breach of bail being detention, where detention's no longer possible, bail also no longer possible. Claimant said, same applies 2016 Act, it's an ordinary form of bail. If you look at 1.5 on the slide in front of us, when reference there is made to a person being liable to detention, the argument was that must mean liable to lawful detention rather than liable to false imprisonment. And if it's an ordinary form of bail, then it means that once a person cannot be detained, they can't be maintained on bail any longer. The defendant argued that Schedule 10 does create what was described as an extraordinary form of bail, that it enables the Secretary of State to maintain a person on bail, even where that person can't be detained under paragraph 10, which I showed you earlier. And that means that even where it exceeds the Hardial Singh limits, so a person, there's no realistic prospect of them being detained, detention can be maintained. Now, as common ground, however, there's one exception to that. If it's simply impossible to detain a person, so you've reached what was sometimes called the Tan Tay Lam extreme. Some of you will remember the Tan Tay Lam case was a Privy Council decision where Vietnamese boat people had travelled to Hong Kong and there was simply no prospect of their being returned. If one's in that situation, Secretary of State accepted, no jurisdiction at all. Mrs. Justice Lang held that Parliament had intended that immigration bail under Schedule 10 should replace temporary admission and temporary release. And so the new system was effectively a redrafting of temporary admission that previously subsisted, and it didn't need to be read in the context of the canons of construction around bail. And she said that the phrase liable to detention in paragraph 1.2, which we can see on the slide in front of us, should be interpreted in the same way as it was in Khadir, where it pertained to temporary admission. And she said Parliament's intention, therefore, was to replicate that system of temporary admission, albeit in the context of a scheme of bail. And that Schedule 10, she said, therefore, did use what she describes as the clearest possible words so as to make bail available in a case in which the background detention power couldn't be used. So the consequence now is the Secretary of State can maintain people on conditional immigration bail long after it would be unlawful to detain them under immigration powers, for example, because there's no prospect of deporting them. So the main effect of that is that rather than have to grant a conditional form of leave, which is what the claimant contended, which in effect is indistinguishable from bail, because a grant of leave can also be subject to conditions not allowing the person to work, they are now maintained on bail. And the one real difference is that that person then can't accrue a right to remain by virtue of the stability of their private life, because where a person's been on bail, that's a far more uncertain form of residence here than one with leave. And so even after many years, they may well not accrue the weight necessary to establish an Article 8 type claim for leave. There was also an Article 5 argument that the claimant put that if the interpretation of the statute wasn't correct, it's a matter of the common law, then what results is an incompatibility with Article 5. But the judge simply held that Article 5 has nothing to do with it, because bail, she held, doesn't deprive a person of their liberty, or does so only in extremely rare circumstances. I've been asked to finish at 11:30, so I've managed to stay within my time unusually. There'll be time for questions at the end, but I'll pass now to the next speaker. Thanks very much.
Thanks. I hope that you've all kept safe and well during the most recent lockdown, that you're not too hungover from the release last night, and that you've all finally worked out how to hyperlink your e-bundles. Despite the Secretary of State's various assurances to the Divisional Court in the detention action case back at the start of the first lockdown, unfortunately, numerous individuals still appear to have been unlawfully detained. I guess the upside is that despite Home Office decision-making until recently having ground to a halt, there has still been much to do for immigration lawyers. I plan to start with the detention action case and then address a couple of cases that have followed on from it. Now, this case was heard right at the start of the lockdown, in fact, I think just before, at a time when there were real fears that detention centres and prisons would become breeding grounds for infection, akin to the cruise ships that had been so blighted during the first few months of the year. Now, fortunately, those fears proved fairly unfounded, so that while there have been COVID deaths in custody, if anything, I believe the numbers are lower than the general population, presumably as the average age in prisons and immigration removal centres is rather younger than outside, but in fairness, maybe even careful management by the prison and detention authorities. Detention action brought this case, along with the detainee, Mr. Raven, first obviously seeking Mr. Raven's release, but also challenging the perceived lack of proper protection for detainees from COVID-19, and seeking in particular the release of all those who, if they'd been out of detention, would have been required by Public Health England to shield themselves. In its judgment, the Divisional Court summarised steps that had been taken by the Secretary of State and notified to them in advance of the hearing to respond to the pandemic, and which by that time, as I say, had been notified. Just reading through briefly this first slide. First, guidance had been provided on hygiene, which had been issued to detainees, cleaning materials were to be provided, and individual IRCs were to devise plans for isolating individuals at increased risk. Second, guidance had been issued to Secretary of State's caseworkers whereby individuals from countries to which removal was not possible were to be brought into detention, were not to be brought into detention unless they were considered to pose a high risk of public harm. Third, the adults at risk guidance was to be applied to anyone identified as being at heightened risk from COVID-19, so that by the date of hearing, the number of immigration detainees had been reduced from 1,200 on the 1st of January to 736, while a number of other detainees had been identified for release and/or review. The fourth step was that those at heightened risk who were not released, steps were being taken to reduce contact with others and support to self-isolate. Fifth, the detention of those not in high-risk groups was to be reviewed by reference to whether the proposed country of return was accepting removals, applying standard Hardial Singh principles. And sixth, guidance had been issued regarding symptomatic individuals in the IRC estate, providing for isolation for 7 days and, if necessary, hospitalisation. In light of these developments, the focus of the claim by the time it came to court had changed somewhat. The charity's interim relief application changed its focus to seeking the release of all those not posing a high risk of harm and facing removal to countries to which the Secretary of State was unable to fly them, i.e. a fairly simple extension of the second step to those already detained as opposed to those coming into detention. As for Mr. Raven, by the time of the hearing, it transpired that the Secretary of State had agreed to his release, albeit that she said this had been decided on a pragmatic basis and not on the basis that his detention had been in any way unlawful. I'll finish, as I say, speaking about this judgment, but then return in due course to the second and third steps. And I should also add that my talk, I think, was initially advertised as an update on the adults at risk policy and Hardial Singh, but having reviewed the recent case law, it seemed to me that there haven't been any really notable developments with respect to Hardial Singh since the last landmark detention seminar, so that it would be better to focus on the adult at risk policy. I hope that no one is disappointed, and if I have missed anything critical, please do let me know. So back to the divisional court. The court refused interim relief and bypassed consideration of Hardial Singh on the basis that even if removal was impossible, the Secretary of State was entitled to a period of time to review the large number of detainees, given the exceptional circumstances that she was facing. Moreover, it appeared to the court that she'd put in place an orderly system for carrying out those reviews. Now, that was surely a fair point, but the court then proceeded to state, the claimants contend that because the Secretary of State has decided as a general rule not to initiate detention for persons who would be removed to countries who, because of COVID-19, are not presently accepting removals, it must follow that detention of any person in an immigration detention centre pending removal to such a country is already unlawful. We do not agree. The two classes are not in materially the same position. Now, this was almost the entirety of their reasoning, and I'm afraid it continues to baffle me. Applying the court's logic, a foreign national offender presenting a low risk of harm and in immigration detention, say since November 2019, should have remained detained on the 25th of March. But a foreign national offender with the same risk profile, but whose criminal sentence was finishing on 25th of March, should have fallen to be released immediately. Now, I just cannot see why the court approved this disparity. If anything, logic surely dictates that if one were to be prioritised over the other, and I'm not saying there should be any prioritisation, then it was the immigration detainee who should have been released, not the prisoner, surely. Matters, I'm afraid, got worse, and for the claimants, because then towards the end of the judgment, at paragraph 35, the court stated, in our view, a sensible cooperation before this case would have led to the same result. So that the claimants, rather remarkably, were ordered to pay the Secretary of State's costs on the basis that the claim had been brought prematurely, and that sensible cooperation would have brought about the same result. Now, poor Mr. Raven, it should be remembered, successfully obtained his release, albeit apparently for pragmatic reasons. And in fairness, it does seem from the judgment that his health condition wasn't particularly serious. While we don't know the full facts from the judgment, as nothing is said about the extent of his risk of harm, offending or absconding. The charity, meanwhile, had ensured through their actions that the defendant promptly outlined in a public forum her policies in response to the pandemic. Now, to me, it seems rather surprising to see Mr. Justice Swift, who as recently as 2018 was still at the bar conducting cases for the Secretary of State, to have had such a rose-tinted impression of the Secretary of State's ability, let alone willingness, to engage in sensible cooperation. It has to be said that the lack of subsequent cooperation, both with respect to steps 2 and 3, rather undermines his and Lady Justice Sharp's faith. So moving back to the second step, which could be summarised as saying no detention where removal is impossible unless there's a high risk. Now, during the summer, I was instructed in a number of cases where this policy appeared to be extremely relevant. Various clients had been detained both before and after the 25th of March. I say it appeared relevant as despite repeated requests in those cases, I've still not seen the policy. So much for sensible cooperation. Now, given the Home Office's unfortunate tendency towards undisclosed policies, without detention action's impressive efforts, one wonders how long otherwise we might have waited for the disclosure in paragraph 5 of the detention action judgment, which at least disclosed sufficiently the generalities of the policy to enable immigration lawyers to aid the release of their clients. Now, as a further aside, a couple of my clients were detained after the 25th of March on the basis that they presented high risks of harm, remaining detained through to June and July. Now, once full disclosure was provided with the defendant's summary grounds, it was apparent that their OASIS reports indicated medium or low risk. Now, of course, the Secretary of State's main detention policy dictates that the expert OASIS assessment takes precedence, just by reference to the old policy, the policy that still pertains from the Enforcement and Immigration Guidance, 55.3.2.6. Now, this is, of course, a well-known and frequent flaw in the respondent's initial detention decisions and detention reviews, but normally the significance impacts the length of the Hardial Singh reasonable period, so likely further down the line from the initial detention decision. But in the context of such a seemingly clear policy, clearly it impacts detention here from the start. And I should add, I understand from the BID website that in the 3 months between 1st of April and 30th of June, over 1,800 people entered immigration detention for the first time. Now, clearly many of these people will have been high-risk foreign national offenders, but one suspects that a large number were not. Now, assuming that removal was not possible to many of their home states, then one suspects that a significant chunk of those 1,800 will have been unlawfully detained. Now, though this policy was referenced both in detention action and in the Bello case to which I'm just coming, and has been raised in many claims which have since been transferred to the County Court for damages following release, as far as I'm aware, there is yet to be any reported judgment considering it or indeed disclosing it. Next, the detention action third step identified by the Divisional Court, and in this respect, the case of Bello is directly relevant. Now, a brief reminder that the Secretary of State's adult at risk policy presumes that adults at risk will not be detained. However, of course, there are various degrees of protection depending on the level of risk, so that the Secretary of State generally will be able to rebut that presumption to detain for those at level 1 and often level 2. By contrast, for those to be found to be at level 3, the highest level, the Secretary of State can only detain where removal with all necessary protection arrangements is set for the immediate future, or the individual presents a significant public protection concern. This summary might surprise some people for failing to refer to the part of the policy referring to those subject to a 4-year plus custodial sentence. And I'll jump ahead briefly at this stage. In the final judgment in this case, Mr. Justice Johnson noted the following concession, that the reference to 4 years imprisonment is merely a trigger to consider risk, and that ultimately the question is whether the individual poses a significant risk. I won't read the passage, you have it there on the slide. So back to the case itself. Mr. Bello had been convicted in 2009 of such awful sexual offences that, but for his severe mental health problems, the sentencing judge stated that he would have been sentenced to a life sentence. The claimant also is in extremely poor physical health, suffering of particular reference to COVID-19 from diabetes and asthma. Instead of imprisonment, he was sentenced to an indefinite hospital order, and he was released from that order into supported accommodation in June of 2018. Now, various appeals have been rejected by then, and an attempted deportation in April 2019 had failed, according to the defendant at the the interim relief hearing, owing to obstruction by his family, although subsequent disclosures suggested this may not have been so. But critically, and in fairness, perhaps somewhat surprisingly, by the time the claimant was detained for removal, when reporting in December 2019, he'd been assessed as presenting a low risk of harm and a low risk of reoffending and a medium risk of absconding. Now, between December 2019 and March 2020, there were 4 attempted removals. The first on 19th of December failed due to the Secretary of State failing to book escorts. The second on the 23rd of December failed owing to the Secretary of State failing to provide the claimant with proper notification of the removal. On the 1st of February of this year, the Secretary of State surpassed herself and both failed to book escorts and to notify the claimant. So that one didn't happen. And then finally, again on the 14th of March, she appears to have failed to book escorts. And shortly after, the lockdown began. Now, given that sorry history, it's perhaps surprising that she defended the claim so vigorously, thereby publicising those serial failings. The first neutral reference with a hyperlink in the slide is to Mr. Justice Chamberlain's judgment on interim relief. The claimant issued proceedings on the 9th of April 2020, and the interim relief hearing was then heard on the 17th of April, by which time the defendant had filed summary grounds. Alas, less than a month after the Divisional Court's judgment in detention action, their faith in the Secretary of State's cooperative spirit was rather shown to have been misplaced. As of the 17th of April, their approved transcript had yet to be produced. And as I understand it, at the first hearing, Tim Bewley QC relied on an agreed note of the detention action judgment to the effect that level 3 applied. However, in the absence of an approved transcript, and with the Secretary of State's counsel denying this, Mr. Justice Chamberlain understandably erred on the side of caution, stating the following at paragraph 30, and adjourned to a rolled up hearing. So critically, the final sentence, I see some force in Mr. Bewley's suggestion that all individuals would be categorized at level 3 risk, but the answer to that question is yes, but I do not think the answer is obvious. So interim relief was refused and the case adjourned. Now, the final hearing took place before Mr. Justice Johnson, and the second neutral citation is to his judgment. Unfortunately, for reasons unknown, that judgment's yet to be passed to Bailey and other online providers. So I'm grateful to Elizabeth Cleaver from Bindmans for supplying a copy. Critically, by the date of that hearing, the 29th of April, it transpired that the third step identified in detention action as Tim had suggested for the claimant at the interim relief hearing, had indeed been a formal policy that in fact had been adopted on the 20th of March. Moreover, the answer was in fact very obvious, as that policy stated, and I quote from the judgment at paragraph 35, particular account must now be taken of the latest Public Health England guidance and the risk factors contained therein, which are believed to increase the risk of severe illness from COVID-19. Where these specific factors are identified, individuals should be released and assessed as an adult at risk level 3. Unsurprisingly, the claimant obtained his order for release and the rest of his claim transferred to the county court. There is some limited explanation that was provided as to why Mr. Justice Chamberlain was not informed of this policy and effectively misled by the Secretary of State, denying even the existence of the policy at the interim relief hearing almost a month before. That explanation is recorded at paragraph 36 of the judgment. Mr. Justice Johnson didn't need to make any ruling on what, it has to be said, appears to have been a rather underwhelming explanation. The next case I refer to is the case of O and others against the Secretary of State. This case is Mr. Justice Swift again. It's a great result for the third claimant, but a case worth noting in light of the judge's reference to the lack of clarity in the adults at risk policy as applied to victims of trafficking, and a further discrepancy between the statutory and caseworker guidance, which the judge appears not to have been aware of, but I hope you'll agree appears to be worth noting. It's an issue I've raised frequently over the last couple of years, but yet to see any judgment on it. The claim started with 3 claimants, all seeking interim relief. 2 were released prior to the interim relief hearing. And at paragraph 2 of the judgment, the judge noted it was almost inevitable that the appropriate venue for those claimants' remaining damages claims would be the county court. I've just made a brief reference to Lord Justice Dingaman's judgment in ZA Pakistan, which reiterates that point about transfer to the county court, something he's been stating consistently since the case of Swarren in 2014. The facts of the third claimant, E, who had not been released, are desperately sad. She's a Greek national who came to the UK in 2017 and was then working as cabin crew for a commercial airline. In April 2018, she was kidnapped, held hostage and sexually assaulted. As the judge put it, this traumatic experience led to profound changes in her life. She appears to have lost her job, become a heroin addict and fallen homeless. And during 2019, she was convicted of 12 discrete criminal offences. Her final sentence was to 7 weeks imprisonment at the end of 2019, and she remained in immigration detention thereafter, pending deportation to Greece. In 2018, the claimant had been referred to the National Referral Mechanism and received an initial positive reasonable grounds decision, i.e. that she was a potential victim of trafficking. Shortly after, she absconded and a negative conclusive grounds decision was taken in her absence. However, by the time of this hearing, she had successfully sought to reinstate the trafficking claim, and it appears that the Secretary of State, while resisting release, accepted that she should be treated as someone with an outstanding positive reasonable grounds decision. Now, this is where things get messy. Mr. Justice Swift noted at paragraph 11 that the adults at risk policy suggested that for those subject to a positive reasonable grounds decision, their detention should be considered on the basis of statutory guidance on the Modern Slavery Act. In fact, it depends on which adults at risk policy you consult, as the internal guidance refers the reader to frontline guidance, which in fact makes no reference to detention at all, while the statutory guidance does indeed refer to the modern slavery guidance. The judge noted that an earlier policy had presumed the release save where detention was necessary on grounds of public order. However, the new modern slavery guidance referred to detention only in a rather obscure annex relating to accommodation, and which stated, in cases where individuals are being held in detention, a positive reasonable grounds decision does not require the individual to be released where there are reasons of public order not to do so. To my mind, actually, if you think about those words, it's a strange way and location for saying the same thing as the earlier policy, and clearly appears to stem from an understanding that that policy remains in place. However, without a doubt, as Mr. Justice Swift put in his judgment, it appears that someone dropped this specific policy ball somewhere between the adults at risk policy and the modern slavery guidance, so that the two just don't link properly. Ultimately, after reference to the Court of Appeals judgment in TT Vietnam, he agreed to release the claimant on this ground, so the case ended well for E. As an aside, anyone running cases along these lines should be aware of the judgment of Deputy Judge Monahan QC in CP Vietnam, 2018 EWHC 2122. Sorry, I haven't put this reference in the slide. Unfortunately, that appears not to have been considered by the later Court of Appeal in TT. It gives a really comprehensive dissection and explanation of the trafficking policy and the definition of public order. Finally, there's a further policy muddle with respect to E's claim to be a victim of torture. Mr. Justice Swift accepted that she had supplied evidence of torture, but found her to be an adult at risk level 2. He concluded, therefore, at paragraph 18, he would not have found there to be a real prospect of E establishing her detention was unlawful on this basis. In so doing, he appears to have followed the Secretary of State's internal adult at risk policy of March 2019. And I'm running out of time, so I'll just ask you to note what's said there and what I've quoted in the slide. There was no specific evidence that the detention was likely to cause harm, which is a requirement of the adults at risk internal guidance. So on that basis, Mr. Justice Swift appears to have been right. However, there are, of course, 2 adult at risk policies. Why there are 2 is beyond me, but there we go. Mr. Justice Swift here appears at this point not to have been referred to the current statutory guidance from July 2018, that which is issued in accordance with Section 59 of the 2016 Act, and presumably the guidance that ought to be preferred if there is any discrepancy. Now, I've put the relevant passage from that policy again in the slide. Now, of course, as discussed earlier, the significance of being a level 3 adult at risk is enormous. And if you look there at the bullet point, having been a victim of torture, and then in brackets, individuals with a completed medico-legal report from reputable providers will be regarded as meeting level 3 evidence, provided the report meets the required standards. So if you've been a victim of torture and you've got the evidence, under that policy, you're level 3 and you fall for immediate release. I believe this is a matter that will need a judicial review, a judicial ruling in due course, or for an amendment of one of the policies. I should add, finally, I've discussed this final issue briefly in advance of this talk with Graham, and he reads that statutory guidance as being consistent with the internal guidance by reference to, I think, primarily paragraph 9 of the statutory guidance. There's no doubt room for further debate, which may follow in due course. But now over to Graham to explain the detained fast track litigation.
Thank you. So the final portion of the webinar today is looking at the detained fast track and how issues arising out of the detained fast track continue to trouble the courts and continue to be relevant to practitioners at the present day. There's a fairly labyrinthine route that leads up to the issues that are currently before the courts and currently live in various civil claims and so forth. And it's very difficult to talk about the current cases without placing them in the context of what the DFT was, what led to the DFT being suspended and never subsequently reinstated, and what the judgments of the admin court and the Court of Appeal a few years ago decided that have led to the issues that are still awaiting resolution at various levels in the courts. So I'm going to begin with a sort of whistle-stop tour of what the DFT was, how it worked, the detention action litigation in primarily 2015 that led to it being suspended, the cases subsequent to that, and then concluding with the issues that are still live in the cases that are ongoing at the moment. As I say, it's a process that ended in July of 2015, but the repercussions live on. And I think for many practitioners who've started work over the past 5 years or so, you may not be familiar with the details of it, but certainly if you're working with people who've been detained, you're working with people who've claimed asylum, or I'm conscious that we have quite a few GLD people on the in the webinar as well. If you're on the other side of these cases, then you're going to need to know what the DFT was and how these issues continue to sort of reverberate down the years beyond its conclusion. So what was it, and why are we still talking about it? It was a process defined in Home Office policy, the intention of which was to provide for the speedy processing of asylum claims whilst the asylum applicant remained in detention. Its various iterations date back to 2000, and it was suspended in 2015 in the face of multiple legal challenges. It's never been reinstated, although there is a new mechanism for dealing with asylum claims in detention that I'm not going to speak about today. And the legal controversies arising out of it continue. The case of TN Vietnam was before the Supreme Court earlier this week, with judgment, I presume, expected in the next couple of months. Okay, so why are we still interested in it? The first reason is that it has ongoing relevance to immigration advice that practitioners will be required to give clients. Decisions that, if people are still in the UK, or indeed if they've been removed, decisions that were taken in the DFT will have relevance to fresh claims that they're making, may be subject to challenge such that earlier decisions could be quashed and appeals reinstated. As we'll see when we look at the cases, it may even be possible to obtain orders for people to be returned to the UK who'd been removed following decisions in the DFT. It's also the case that if people were detained unlawfully in the DFT for the purposes of processing their asylum claim and subsequent removal, they may well have a viable false imprisonment claim that they can bring in the QPD in the county court. And there is quite a bit of overlap between the issues that are relevant to the immigration side of things and the issues that are relevant to the detention side of things. So what precisely was the DFT? How was it formulated? As I said, it was in existence for about 15 years, and the policy documents that sort of comprise the DFT changed over that period. But in its most recent iteration, it was broadly defined in two Home Office policy documents. One was called Detained Fast Track Processes, which had reached version 6 by the time the DFT was suspended. And the other one was called Detained Fast Track Processes Timetable Flexibility, which was at version 2. The 2012 version 2 version was still current at the time the DFT was suspended. If you're dealing with cases arising out of the DFT that predate that, you'll have to do your best working through the government archives to find the relevant policy documents from the time that your client or your case relates to. There were two facets to a decision to route a case into the DFT. The first was that the claim itself had to be suitable for a decision within the DFT, and the core criteria for that was was that the case was one in which a quick decision was possible. Quick was defined as roughly 10 to 14 days, possibly a bit quicker than that. Quick decision in this context, clear from both from the policy and the authorities, means a decision that means that a quick decision that is fair and sustainable. Obviously, a quick decision can be made in any case, but whether it's a fair and sustainable decision will turn on the particular facts of the case. And there's quite detailed guidance in the policy that's glossed by case law. as to the factors that need to be taken into account when the Secretary of State is deciding whether or not an asylum claim was suitable. And the second facet of this was that the individual claimant, the individual asylum applicant themselves had to be suitable for the DFT process. And there were what were termed the DFT suitability exclusion criteria set out in the Detained Fast Track process's policy document, which identified categories of individual who should not be routed into the DFT because of their particular circumstances. And very broadly speaking, it was to ensure that vulnerable individuals didn't have their cases considered in the DFT. There's quite a bit of overlap between the categories in section 5510 of the EIG of the circumstances where people would not normally have been suitable for detention under the then general detention policy and the suitability exclusion criteria, but they're not completely on all fours, so it's necessary to look to the DFT policy when considering whether a person was, a vulnerable individual who should have been routed away from the DFT for that reason. It included factors such as pregnancy, physical and mental illness, whether or not there were reasonable grounds to believe a person was a victim of trafficking, evidence of torture, and so on. The information on which the decision to route a case into the DFT was based was primarily the information that was gleaned at the screening interview stage, although the policy did make clear that if information came to light subsequent to that established that a personable case was unsuitable for DFT, they could be, and indeed should be, removed at that stage. In terms of what needed to be asked at the screening stage, and again, I can only sort of deal with this in the briefest terms possible, that there is a lot more detail that can be gone into on this, and one needs to look at, for example, the first of the detention action judgments for the discussion of the screening interviews there to get more detail on this. But broadly speaking, in order that a lawful decision could be taken, sufficient inquiries had to be made as to the nature of the claim. Sufficient didn't mean detailed, and indeed there is other guidance that makes clear that the screening interview should not be too detailed for general asylum determination reasons, because it's unfair to question a person in detail about their asylum claim at that stage before they have legal advice and so forth. So the Secretary of State had to sort of strike a balance between ensuring sufficient detail was obtained to make an informed decision about whether or not the case was suitable for the DFT, but not going so far into the case that they were potentially prejudicing the asylum determination process further down the line. And the sort of inquiries that needed to be made were the factual and legal basis for the claim, to get a sense of its factual and legal complexity, the evidential basis of the claim, particularly the scope for potential corroborative evidence, which could be in the form of witnesses, could be in the form of medical evidence, could be in the form of expert evidence, and so forth. Did a fair determination of the claim require that the applicant be given an opportunity to get that sort of evidence, and could it reasonably be obtained within the very truncated DFT timescales? Was there a need for obtaining further documents? Was there a need to get translations? Could those translations be done within the DFT timescale? And so forth. And obviously, once a certain amount was known about the case, then the additional inquiries that were required turned on what had already been disclosed by the applicant. One point that's pretty clear from the authorities is that claims which turn on corroborative evidence from external sources that can't be obtained within the relevant timescale may well be unsuitable for the DFT. And the paradigm case there is JB Jamaica, which was an asylum case based on the applicant's sexuality, where it was clear that in order to make good the account that he was putting forward, he was going to need to obtain details from third parties that couldn't be obtained within the sort of timescale that the DFT allowed. And in those circumstances, the decision to route the case into the DFT was held to be unlawful. So how did it come to an end? Well, there was this fairly spectacular raft of strategic litigation brought by the charity Detention Action, who, as Philip said, have also been active more recently in the issues around COVID-19 and adults at risk. But there were a whole succession of cases that were brought challenging different aspects of the DFT, which cumulatively had the effect of knocking out different bits of it to the point that the government eventually withdrew the policy as a whole. There are 6 decisions in all, of which 3 are really critical for our purposes today. So I'm going to focus fairly briefly on those 3. The first detention action decision, which I'll refer to as DA1 in 2014, was a decision of Mr. Justice Easley, where he conducts a sort of sweeping review of all the different facets of the DFT, the way the screening process worked, the way vulnerable applicants were worked. He looks at different categories of were considered, and he looks at different categories of vulnerable applicants, access to legal advice, and so on and so on and so on. And he identified numerous flaws in the working of the DFT as a whole. But he came to the view that none of those flaws individually rendered the system so unfair as to be unlawful, so long as the applicants had prompt access to legal advice that would enable them to deal with any of the shortcomings that arose. But on the evidence that was before him, they didn't have that access. So he found the DFT regime as a whole to be unlawful, but the sort of tipping point issue, the thing that led him to that finding, was specifically the lack of speedy access to legal advice. And in terms of what flowed from his judgment, he gave a separate judgment on remedy, and that judgment was then appealed to the Court of Appeal. And the relief that he granted went no further than a declaration saying that the DFT had been unlawful as at the time of his judgment for the reasons given. So nothing flowed from that automatically in terms of individual cases, but his critique of the different aspects of the DFT bears very close study, depending on the particular issues that arise in given cases. There was then a separate case that ended up before the Court of Appeal about the policy of the Home Office to detain within the DFT beyond the point of the asylum decision pending the outcome of an appeal, and the Court of Appeal accepted that policy was so unclear that detention on that basis was unlawful on sort of lumbar principles, that a policy governing the exercise of detention powers has to be clear, and if it's not, detention under that policy will be unlawful. And there's a recent decision called PN Uganda in which you'll see Mr. Justice Lewis applying the principles arising out of Detention Action 4 to the detention of the claimant in that case. And then of particular importance for the issues that are still troubling the courts at the moment was the decision of the Court of Appeal in the last of the detention action cases, Detention Action 6, Lord Chancellor versus Detention Action, which was an appeal from Mr. Justice Nicholl in the Administrative Court, where he had found that the procedure rules, and the dates are important here, the 2014 procedure rules governing fast track appeals in the first tier tribunal were unlawful because of the very truncated timescale that they provided for. That was appealed to the Court of Appeal, and his decision was upheld by the Court of Appeal in fairly resounding terms. And you'll see the sort of key passage, from the judgment of Lord Dyson set out on the slide there. He said the appeals regime under the fast track rules 2014 was unlawful because the time limits are so tight as to make it impossible for there to be a fair hearing of appeals in a significant number of cases. And it's important to note that phrase, a significant number of cases. He does not say all cases, and that's what's led to some of the subsequent controversies. The system is therefore structurally unfair and unjust. The scheme does not adequately take account of the complexity and difficulty of asylum appeals, and so forth. So the the DFT appeals regime, as it was enforced at the time under the 2014 rules, was found to be ultra vires. As I said, litigation since then has focused on the implications of that decision in particular, and the circumstances in which an appeal determination by the first tier tribunal should be set aside or quashed. And as I said at the outset, that's of particular importance, both in terms of a person's immigration position, if they're continuing to assert a protection claim, or even if they've been removed, and as regards the legality of detention during the time they were detained for the appeal. Because as you'll probably be aware from the Supreme Court's recent decision in DN Rwanda, if a decision that is prior to a detention decision but is the foundation of the detention decision is unlawful, then it will follow that detention is unlawful too. So if you have detention predicated upon the fact that an appeal has been dismissed, but that appeal itself was unlawful and was a nullity, then so the argument runs, and in my view, it's an argument that's clearly been accepted by the Court of Appeal and subsequently in PN Uganda. It follows that detention was necessarily unlawful both during the unlawful appeals process and following the outcome of the unlawful appeals process. But the way that's been dealt with subsequently is complex, and that's what I'm going to look at now. So immediately after Detention Action 6, the first tier tribunal, with the cooperation of the Home Office, adopted a practice whereby if individuals who'd had a negative appeal outcome in the DFT simply wrote to the president of the first tier tribunal and asked for it to be set aside, it was set aside under Rule 32 of the 2014 rules, which gave the FTT a power to set aside decisions on grounds of procedural irregularity. But critically, that was done without examining the facts of the case and without considering whether there had in fact been any unfairness on the facts of that particular case. On the state of the law at the moment, it was at least arguably wrong for the FTT to take that approach, although that may yet change again, depending on the outcome of TN Vietnam in the Supreme Court. There's a question mark over whether detention that where somebody was detained following an appeal decision and that appeal was set aside under Rule 32 without an examination of the facts, it necessarily follows that the detention was unlawful as a result of that, sort of retrospectively as a result of the set aside order made by the FTT. A recent county court case that I was involved in that's found its way onto Bailey, Her Honour Judge Boucher concluded that that consequence didn't flow. That may be right, but in my view, it's probably not the last word on that. And the Supreme Court in TN, I suspect, is the outcome of the Supreme Court appeal in TN is likely to bear on whether that is the correct analysis in these circumstances. But there was another issue that was hanging over after Detention Action 6, and that was whether the earlier FTT rules, which had been made in 2005, so they'd been enforced all the way from 2005 until the 2014 rules came in, which were effectively identical insofar as it had any bearing on the operation of DFT. There was nothing to distinguish them on any material grounds, whether they were unlawful as a result of the decision of the Court of Appeal in Detention Action 6. So that issue came before Mr. Justice Ouseley in a case in TN, which is the case that's currently before the Supreme Court in 2017. He found that DA6 did apply to the 2005 rules, so they were unlawful too, but he went on to say that it didn't follow that every decision had to be quashed because the unlawfulness in the rules didn't necessarily mean the outcome of each individual appeal was unfair or unlawful. So far as the procedure for getting it set aside was concerned, he held that the application had to be made to the first tier tribunal. TN appealed certain aspects of that decision to the Court of Appeal, but also applied to the first tier tribunal for a set-aside order following the procedure that Mr. Justice Ouseley had identified as being correct. The first tier tribunal said they didn't in fact have jurisdiction, notwithstanding what Mr. Justice Ouseley had said, so TN judicially reviewed the decision of the FTT, and both of those cases, so both the appeal against Mr. Justice Ouseley and the JR of the FTT's decision on jurisdiction, ended up in front of the same constitution of the Court of Appeal, which produced two different judgments. You have the EWCA, the Court of Appeal judgment, and you have a separate judgment of the of that panel of the Court of Appeal sitting as the admin court dealing with the jurisdiction issue. So in the appeal against the decision of Mr. Justice Ouseley, the Court of Appeal accepted that he was right, that there was no automatic consequence that every every appeal decided in the DFT was unlawful. Each case had to be looked at on its own facts to determine whether or not there was unfairness and whether or not it was in the interests of justice to quash the decision of the FTT. I press for time, so I won't read out the guidance that Lord Justice Singh gave, but in the judgment at paragraph 103, Lord Justice Singh gave quite detailed guidance on the factors that need to be taken into account when considering whether or not an individual FTT appeal decision falls to be quashed. They're set out on these two slides. And then in the JR that came before the Court of Appeal in TN, they concluded that the correct venue was the administrative court and not the FTT. So if somebody wants to challenge an FTT decision made under the 2005 rules to have it set aside, they need to make a JR, which will inevitably be a JR brought long out of time, to challenge that. Hamid was a decision of the Court of Appeal applying those principles to the particular facts of that case. I don't need to dwell on that. And then we end up with a decision of Mr. Justice Lewis in an interesting case called PN Uganda. In that case, there was a challenge to the lawfulness of the FTT appeal outcome, to detention during the FTT process, and to the applicants, to the claimant's removal, because by the time of the case, she'd been removed from the United Kingdom. Applying the principles from TN, Mr. Justice Lewis found the appeal process to have been unlawful for grounds quite similar to the grounds in JB Jamaica. It was a sexuality claim, corroborative evidence was required, there wasn't sufficient time to get it, but that was focusing on the appeals process timetable rather than the initial DFT timetable. He quashed the FTT decision, and critically, and this is very important for people advising clients about the immigration consequences of these decisions, he made an order that PN be brought back to the United Kingdom. He found detention to be unlawful up until the claimant's appeal rights were exhausted, but he said that notwithstanding that the appeal process had been unlawful, the Secretary of State was entitled to rely on the appeal decisions as prima facie lawful, so detention beyond the appeals process was lawful in his view. That issue went on appeal to the Court of Appeal, and the Court of Appeal disagreed with him on that specific point. So in PN Uganda in the Court of Appeal, Lord Justice Dingerman said that the fact that the appeal outcome had been unlawful meant effectively that detention subsequent to the appeal was also unlawful, and paragraph 86 of his judgment in the Court of Appeal makes clear his reasoning. The public law failings in the form of the unlawful rules and the unlawful FTT proceedings were relevant to and bore upon, so that's the test from Lumba, they were relevant to and bore upon the decision to detain. So for that reason, and because the appeal decision was a nullity, the detention which followed it was also unlawful. As I mentioned, the case of Ali, which is where the consequence of the non-fact specific set-aside orders of the FTT were considered. That is in Bailey. And then finally, so far as the authorities go, TN Vietnam is now live. Well, it's just the hearing is finished, but it's live before the Supreme Court. I don't know anything about it beyond what is said on the Supreme Court's website, but they identify the issues as being, firstly, whether or not individual decisions taken under the 2005 rules are automatically a nullity. It's very hard it's very hard to see how the answer to that question would be any different in relation to the 2014 rules, whatever conclusion they come to. If not, what's the correct approach to take when considering applications to quash or set aside appeal decisions taken under the 2005 rules? And was there procedural unfairness on the particular facts of TN's case? So that, I hope, brings things up to date. In terms of grounds of challenge, failing that they're open to claimants in DFT detention challenges, failing to make sufficient inquiries at the screening stage will be a viable basis of a public law challenge. Unsustainable conclusions that either the case or the applicant were suitable for the DFT. The unfair appeals process, as we've seen in PN Uganda, the detention predicated upon an unfair appeal outcome, which one gets from the Court of Appeal in PN Uganda. depending on the stage that the particular individual's case is at, it seems to me to give rise to quite complicated issues about venue. If the decision has yet to be quashed, then if it's a 2005 rules case, it seems to me that it has to be brought by way of JR. If it's a 2014 rules case, it may be the tribunal has jurisdiction to deal with the set-aside, and then the civil claim element needs to be dealt with in the QBD or the county court. But obviously, given the timing, all of these cases are going to be very, certainly so far as civil claims go, are going to be very close to their limitation deadlines. So prompt action and careful thought about the appropriate venue and the timing for issuing is going to be essential. And obviously, there are the immigration aspects to this as well. And as PN, the first instance decision in PN demonstrates, it is not fanciful to suggest that in appropriate cases, an order to bring somebody back will be made. It's also the case that obviously if a tribunal decision is quashed, the appeal remains live, and you're not stuck with the sort of Devasithan approach where that earlier determination is the starting point, because that determination is a nullity. So I've slightly overshot my time, but we're still got 5 minutes or so for questions. So yes, if I can invite Alex and Philip to come back onto the video, we'll field any questions that that people have. So the first question relates to the DFT, and it relates to the point I was just speaking about, actually, the fact that most DFT cases were over 6 years ago. How does one get around the 6-year limitation period in relation to bringing civil claims? There isn't an obvious answer to that. I mean, there's no, if one is seeking a quashing order for the FTT decision, then there's no, I mean, the starting point, it was a JR application, the starting point is obviously a 3-month limitation period, but that's extendable at the court's discretion. You know, the further one gets from the decision, the harder it's going to be to get the court to exercise that discretion. But if appropriate reasons can be given, and it will be a pretty unusual case, I would have to accept, then getting the decision quashed more than 6 years after it was made is not inconceivable. But unless it's a PI case where unless there's a personal injury element to the case where the court has a discretion to extend the limitation period, then there are likely to be difficulties bringing civil claims more than 6 years after the period of detention that's in issue. There's a question for Alex. I mean, I think this may have been implicit in what you said, but I was just wondering if you can say a little bit more about, or sort of work through what the potential consequences would be if the claim in Kaiti ultimately succeeds.
I think the consequences would be, well, our submission is the consequences are that he and those in positions like him need to be brought into the regime of discretionary leave, as opposed to being maintained on bail. And there's actually a decision just this morning which suggests that is less unrealistic than the judge, Mrs. Justice Lang, thought. The decision this morning is a decision of Miss Justice Mostyn. And in the case in front of him, it's called EOG 2020 EWHC 3310. There was an application made by a trafficking victim, and she argued that under the Trafficking Convention, the extraordinary delays in making reasonable grounds and conclusive grounds decisions were incompatible with the convention, and that she shouldn't have been maintained on bail for the year that it took to make a reasonable grounds decision, and then a further year while they made a conclusive grounds decision. And Miss Justice Mostyn agreed and said that there was a lacuna in the scheme there, because she was being held without a proper permission to work without leave, simply because of the Secretary of State's inability to operate the system in accordance with the convention and the intentions of Parliament. And that there needs to be an amendment to the system so as to grant trafficking victims leave. And one of the reasons for that is, he noted, a Court of Appeal decision in which it was said that well, it was made, the point was made that under Section 24 of the Immigration Act 1971, it's actually a criminal offence to be within the jurisdiction without leave. And so it does seem on that basis that there is more to the argument perhaps than Mr. Justice Lang was willing to accept. And similarly, what the claimant relied on in the Supreme Court was the case of George. Relied on the case of George in the Supreme Court, in which Mr. George had leave to remain, indefinite leave to remain, had it revoked, and the question was whether the leave revived once his appeal succeeded, and the answer was it didn't. And the court said, but his leave did have to be regularised. He couldn't just be left on bail in that case, and so successive grants of discretionary leave were made to Mr. George. So it does seem that there is support for the idea that people should not simply be left in this irregular position for extended periods of time in varying different contexts. So that's what we say, and the reason that's supported in terms of the statutory scheme is that when the new bail system came in, yes, the old temporary admission system was overtaken, but the leave system has also been amended so as to effectively make forms of leave very similar to bail, because you can have all sorts of conditions imposed on your leave, like condition prohibiting work, condition prohibiting recourse to public funds. So being granted leave is hardly a great boon anyway, if it's subject to those kinds of conditions. And so there's no real reason why a person shouldn't be on leave rather than on bail in terms of the controls available to the Secretary of State. All that it means is that you are not here unlawfully, and you can accrue some right in the long run to be granted a more substantial form of leave. So that's where the argument sort of is directed, to just not leaving these people who are in a kind of limbo status effectively for their whole lives in that limbo status.
Thanks, Alex. I feel like this isn't a question as such, but I think you've identified an issue about release timetable that you just wanted to add something on.
Sorry, actually, rather than that, one thing that occurred to me while I was listening to your talk, sorry to cut across, I think Fiona in opening today was supposed to say something about our former colleague Stephen Naffler, QC, who I think this is the first seminar that we've put on since very sadly he passed away. I think, I'm not sure if it was last month or I think it was the beginning of last month, maybe the end of October. And the reason it occurred to me was that you referenced in PN Uganda the Court of Appeal overturning Mr. Justice Lewis on the detention aspect. And of course, in fact, the basis on which they were able to overturn Mr. Justice Lewis was, I suppose, one of Stephen's final remarkable successes before the Supreme Court, which was DM Rwanda. And that was the basis on which they then found that Mr. Justice Lewis had got things wrong. So it seemed appropriate. I think Fiona, as I say, was going to make reference to Stephen, and I think how much everybody within Chambers and the whole immigration field misses him.
Indeed, yes. Thank you for raising that, Philip. He was a remarkable colleague and a remarkable individual.
Yeah,
very sorely missed at the bar.
I see that we have another question that's saying if a detainee may, even though a detainee may be regarded as a level 3 adult at risk, quite often the Secretary of State maintains detention. What steps should we take to challenge the unlawfulness of continued detention? Well, I think it's, I think letter before action, and straight in, and given that one's dealing with a level 3 adult at risk, I note that there's stuff that's said about going too quickly to court in the detention action case, but my own feeling is that letter before action probably need only give 7 days, some might say even less, for the Secretary of State to respond, and then seek to bring the claim as soon as possible thereafter.
Yeah, I agree with that. I mean, that guidance about allowing sufficient time, that can't possibly permit truncated timescales in cases where people are at serious risk of continued detention.
Yeah, and it's implicit in level 3 that that's the case. Yeah.
Great. Well, we're slightly over time. We've still got 66 participants on the webinar. So thank you to everybody who's joined us today. Thanks to Philip and Alex for extremely interesting and informative talks. And yeah, I hope everyone's found this a useful session, and we look forward to seeing you at future sessions. Thank you.